Then what happened? Okay.
Just got it. You have to
Just
have
very old, right?
That has to be ratified by.
Okay. It has to be ratified by 3/4 of the states. And that's the legislatures of those states. Remember that at the time the Constitution was drafted, states' rights was a big deal. It still is, because of the way we design these institutions. State legislatures are awfully important because the people that went to the convention to draft the Constitution were representatives of their states, and they saw themselves primarily as citizens of states who were associating for some purposes in a national constitution. So 3/4 of the states. I mean, there is another way to do it. You can have a constitutional convention that gets called, but that's never happened. That's never happened. And the chief reason is,
How close are we in terms of governor and none of the governor are the Republicans who calling for one,
how close are the Republicans to?
calling for a constitutional convention?
Oh, they never tried it.
Aren't they only about 3 governors short right now?
Not that I'm aware of. You know,
Okay, get back to
they
that.
might,
Get back to
they,
they're only about.
they might be able to get with a number.
No.
What you're saying is, could
No.
they do it? They might be able to do it. The reason that we haven't had one is that everybody's afraid of it. Everybody's afraid of how radical the changes might be if we started with the people again and try to inject all of that into it. It's just a potential element of chaos. And boy, we have a lot of chaos as it is. So this is profoundly undemocratic. And look at the words. The free exercise of religion. Boy, what does that include? What do we get to exercise and how? Freedom of speech. Is that absolute?
Shouldn't be.
Some justices used to think it was absolute, but you know, with the encounters we've had with our favorite internet lately, I mean, we're really in a conundrum. This country is just how absolute it ought to be, and maybe it needs some limitations of some sort. So all of these terms, I mean, you can go through the Constitution, the Bill of Rights particularly, and you're going to find all kinds of words and phrases and sentences that are ambiguous and that need and require definition. So somebody has to assign meaning. That has fallen to the court. Not because the Constitution specifically designed it that way, because the court as an institution is the one that enforces and determines the law. And in doing that, they will set the limits of those definitions. So back to our program here. For some of you that are new, I'm going to go over this again. Bear with me, those of you who were here last time. We have a couple of major ways we think about how to interpret the meaning of constitutional provisions, which are often quite vague. One of these is called originalism. And this is the one that is really in vogue right now, with, I dare say, close to a majority of the Supreme Court would espouse some form of originalism. The meaning of a constitutional provision is fixed at the time the text is written and adopted. So take a snapshot in 1789, when the Constitution was drafted. That's the meaning we look to capture. Whoops. The last time I looked, this was 2023. And a few things changed. So right away, you have a sense of disquiet about how this is going to work. Original intentions originalism, that's one type of originalism, asks, what did the drafters intend the text to mean? Now, the drafters, James Madison, Thomas Jefferson. The people that went to the convention, the people that wrote the words in the various plans that were presented to the convention and then got moved around and amended and all that sort of thing to come up with the document. Those people, what did they intend? And what can we find in the historical record to show what they meant? Well, the Federalist Papers I mentioned last time is one of those sources, written by John Jay, James Madison, and everybody's favorite on Broadway, Alexander Hamilton. Those three guys wrote those papers, and that expresses their opinions about what it means, but that was reflected, I should say, is directed to a particular audience at that time. They were trying to convince people in the state of New York to vote yes on the Constitution, because the Constitution went through a process of being ratified in the states. So, they were writing to persuade a vote yes. And the way they were doing that is people were raising problems. People were saying, wait a minute. And of course, you'd see editorials, you'd see publications, you'd see things get circulated. Oh, this article is a mess. This article gives too much power, to the federal government. This article does this article does that. All of this kind of thing would be announced, and then, oh, whoa, so all of a sudden there's some disquiet. We want to put that down. How do we do it? The Federalist Papers. We have Hamilton, we have Madison, two terrific writers, unbelievable thinkers. John Jay only wrote a few papers, but they would explain what are we trying to do here, and they would, in the process of that, they would not do this directly and critically. They didn't use a lot of nasty words the way some of our politicians do about the other people that they disagreed with, but they would deal with the disagreements in the context of explaining what these provisions meant. And so that's stories, and that tells you, what was meant there. The other thing is there are records. The Constitution Convention has records, and by the way, the idea that is also in vogue again, that compromise is the work of traitors. People who compromise on things are not being principled. They're not being true to the central value, and they're traitors. That kind of idea, and by the way, that one exists on both sides, of the aisle, and in both parties. There's one party that doesn't mention it all that much, but they do inside the party. They will enforce, the values and norms. They'll conduct purges. They'll do various kinds of things like that. But that's the kind of thing that is au courant. But this was not the way it was done. We didn't get a constitution that way. The people that went into that room, particularly Madison, and the people that disagreed with Madison, these are people that realized we've got to compromise. If we're going to get this thing launched, we have to compromise. Otherwise, it's going to fall apart. Everybody's going to go back to their corners in their states, and we're not going to have, a constitution or a national government. And so they compromised, and there was drafting, and there was redrafting, and there's a record of all of this, and the debates and questions that got raised, and then how, in some instances, particular language got changed. What was there originally got changed. So we can look to some of these sources, historical sources, that will give you an idea what the drafters, the people that wrote it, intended the text to mean. There is a second, however, kind of originalism, and this reflects the fact that this document was not something that the drafters simply put together, compromised in a convention, and then boom, got put in a constitution. No. Constitution had to be ratified. by the states. And so this went out to the voters. And they had votes. So it acted much like what's our institution here in California? The initiative did, you know, what we have on our ballot propositions, that was very much like the way this started. Well, but wait a minute, if it's going to the people, and it starts out quite nicely, we the people, it doesn't say, you know, we the states, it doesn't say we the governors, or we the legislatures, anything like that, it's just we the people. Okay, how are we going to determine what did the people mean when they said freedom of speech? What did the people mean? Well, by the way, freedom of speech wouldn't have been in there at that time, since those were the first 10 amendments. But what do these phrases and words mean? What do we mean judicial power? What do we mean, you know, and what do we mean in all those instances? Well,
Just a reminder, the
Yeah.
people were white males.
yeah, exactly. It's what do a bunch of white males
Landowners.
that went inside and owned, had to own land, and
Were
they
educated.
would get a right to vote if they did.
What was the religious persuasion of those guys?
That was the most pluralistic thing around. Because we had a considerable amount of diversity in religion going into the Constitutional Convention because of the way the colonies were set up.
Right.
There were different prevailing churches in different colonies, and even within colonies that had a prevailing church, people were coming over from Europe and constantly sneaking in and taking a corner because the land was available. And so all of a sudden you started dealing with, oh my gosh, we got all kinds of people here. The reason we have an establishment clause in the First Amendment is because we literally had established churches in the colonies, one church that was identified as the established church, the government created and endorsed church. Well, how long did that last? When did we get rid of establishments of churches in, God bless America?
Was it the Bill of Rights? I don't know.
No. All the Bill of Rights does is at that time refer to what the federal government would do. The reason that clause, the religion clause of the First Amendment, went very quickly through the convention. Everybody wanted that because they were different religions. A number of them came from different persuasions, and they did not want to have an establishment at the federal level that said everybody's going to be Episcopalian. Everybody's going to be Baptist. Everybody's going to be, God forbid, Baptist.
Just a question, but when you say pluralist in religion, you mean Christian,
Right? Definitely.
I mean flavors of Christianity, but you're not talking about Islam or any other religion.
We had practically no Islam, practically none. We did have some Jews in various places. Newport, Rhode Island strikes me, just comes to the top of my head because there's a nice historical record of George Washington writing to that particular Jewish congregation, and basically to assure them that their rights are going to be respected here. But you're right, very few. We're talking about Christians, and not all that many Roman Catholics either. And there was a lot of prejudice against Roman Catholics at this point. But the only thing the Constitution did was say, hey, we aren't going to have a federal establishment. It didn't have anything to say about the states. If we had tried to do that in the convention, oh God, you would have seen a firestorm because they wanted their individual state establishments. They wanted the state to be Episcopalian and the Episcopalian church to be endorsed and supported by the government, et cetera, et cetera, et cetera, all the way through. Well, okay, but then what happened? eventually this fell away. And the reason it fell away is, again, increasing diversity, more settlement in the states, and therefore people just saying, wait a minute, you know, we're pushing for the same privileges. We want to be treated the same way as the established church. And so let's get rid of this thing. Well, it lasted until 1833. 1833 was the last establishment, which happened to be in the state of Virginia. And it was the Anglican or Episcopal Church that was abolished as the established church in the state of Virginia. So, okay, but so what we are talking about doing here is asking, what did the public mean? What did we, the people, mean when they received this Constitution? They heard all these debates, and they took a vote. Because it's what went through their minds and their intentions and their sense of meaning that we should be applying. So those are two versions of what to do with originalism. Now, of course, for the last one, what do you do about evidence? What do you look at? What do you think ought to be looked at to determine the intent of the people?
The referendums.
Well, I mean, but what did you have in that regard? You have a constitution. They were all handed the same constitution they were going to approve. What would there be? What would be the evidence of what they thought, not just what the people that wrote that document thought?
I'm gonna take a stab at this. In terms of originalism, we've got two diametrically opposed views here. I think the public, let's talk about, for example, about freedom of speech and what was the other you're talking about?
Right. Religion, yeah.
Militia. Let me skip that well-regulated militia, because that's another deal. Here, that's better. I'm thinking the people meant by freedom of speech that they could speak out against a hostile government. It's kind of the reason that the founding fathers came here to give. I think that's what was meant. I think that's what the people thought they were voting for. Not to hate speech, but to specifically for that, the right to speak out against the government without being persecuted. Right. This meaning too. I'm thinking about muskets versus AR. So I'm thinking about, if I were a Supreme Court justice, would I be right or righteous? Would I be right and righteous to be a meaning one originalist on those two issues? If I would be right, well, I think I would be very wrong. We have a Supreme Court that by design, this is what people voted for, or one thought they were having. We would have people who would be completely apolitical. We don't have that today, but that's what they thought we would have.
But Lawson, what would you look at to find out what the people thought when they voted? To see whether or not they reflected all of the things that you just said in their
What
vote.
document would they look at, or what
records? Yeah, what would they look at? Yeah,
I don't know.
Well, there were tons of newspapers.
Yes,
print-
yeah,
print-
that would have been
print-
one
press
thing.
that were busy.
And of course, the problem with that source is what? Editorial contradictions all over the place. To square out and try to reconcile all of that and get a meaning out of it is a very difficult exercise. So this is an extremely challenging thing, but certainly media is one thing you read. You can look at some of the sources drafted by the founders if they were disseminated publicly, which the Federalist Papers were. They were in the newspapers in New York. So that's the kind of thing you would look at. Now, fast forward to California. What do? I had part of my job at the California Supreme Court was to determine or ascertain and then recommend to my boss meanings attributable to our state constitution, particularly initiatives, which are done in California routinely. We don't seem to have an election here without something that we have to vote on to add it to the Constitution. And most of the initiatives we vote on are added directly to the state constitution, which is why we've got a state constitution. We've got a federal constitution that's like this, we've got a state constitution that's like this. So, but where do you find out, what did we the voters need?
To those ballot pens.
We got a ballot pamphlet. I hope you guys have looked at that thing, you know, at least a little bit. You know, when you get these things, because you notice in there are meanings that are assigned by the legislative council. Talks about the attorney general's office, talks about the legal meeting, the legislative analyst, I should say, talks about policy. What is this going to result? What are the consequences of this going to be? And then there's a debate, there's a pro and a con, you know, as to what goes on here. And all that material is available. And boy, you read something from the California Supreme Court, you're gonna see that stuff quoted. You know, and in support of a proposed meaning. So there is an official way to determine that meaning. We therefore rely a lot less on press. I wouldn't say that never happens, it has happened. But we really go to those official sources because every voter gets one. What'd you call that?
A ballot.
The ballot pamphlet. It
You
is.
have to ask for that, or?
I'm
new to California.
Are you voting by mail, Joe?
Yeah,
It'll come to you.
okay.
It'll come to your house.
Those pamphlets typically will emphasize the pros and cons of a different initiative, and it will typically tell you the impact on the budget and
Yes,
property.
Yeah, okay.
Whether or not your taxes will be increased or somehow
Yeah.
impacted. But it seems to me that people tend to, I have a reason to believe that people do not really study those pamphlets in terms of their accuracy, but instead resort to looking at ads on TV. Case in point, this last ballot about the effect of closing these supposedly subpar, what do you call, what the papers left? Yeah. If you had, those ads were merciless. The actors or the people would say, you know, I'm gonna die because my clinic's gonna close. And the other people are saying, yeah, but that's a waste of tax money because those people aren't qualified. And, you know, I think people look at ads a lot more than they do. Are able to really evaluate on the basis of
And ads are something, because of free speech, can be put there by anybody,
Yeah, they can lie.
including people
They can
from
lie.
outside the state. We have a lot of funding that comes in from outside of California for interests that want to get a particular initiative passed or defeated. And I remember the famous gay initiative we had. Outside money came
Measure
in
eight.
big time on that.
Yeah.
And you know, so the anti-gay provision prevailed. And so, yeah, but as I say, we have these sources available, all of the things that we mentioned, that can be used to assign meaning. But in any event, meaning is going to be under this approach, yeah.
So those are also available for the ratification of the Constitution, the pamphlets?
No,
Okay.
no, you didn't have anything like that.
Okay.
All you might have some local newspapers that you could look at, but there was no ballot pamphlet. The constitutional text was the only thing that was before the voters. Yeah, Brad.
So the California Constitution was adopted in like 1850 or something, so I'm just curious,
Yes.
these legislative analyst stuff, did it start in the 19th century, or is that more a recent
No.
phenomenon?
No, yes, the California Constitution started in 1850, but initiatives really got off the ground in California at the beginning of the 20th century. So maybe around the 1920s, something like that. And there were, yeah, there was a legislative analyst at that time in the twenties. There were some other things. Those institutions were pretty much in place at that point. But the reason we got initiatives, folks, the big campaign to add to the California Constitution, the prospect that we can amend the Constitution by majority vote of the people and provide for ways in which propositions called initiatives could be on the ballot. All of that was done because of great skepticism about whether our legislature had been and would continue to be corrupted by corporations. That was the big interest at the time. So
They have the second, they have the Citizens United anyways, that just threw everything down the drain.
well, and again, you can talk about that continuing influence and what it has and how it plays out. But in California, this was supposed to be a check on that. And to some degree, it has been. There have been instances where we've overthrown those interests because we have the initiative. Yes.
What
ma'am.
about professional holds and how far do they go back?
Oh, gee, when did people start polling? I don't know the answer to that. You know, certainly we had them by the mid 20th century. But at what point I would guess probably there's some point in the first 50 years, 1900 to 1950, that people started doing that. And then, of course, they got better and better and in terms of the scientific aspects of counting people and doing that. But that's when we started living with that stuff. Okay, now there's one, before we go on and talk about depart from originalism. Originalism, of course, again, this is supposed to be, according to the people that espouse it, a constraint on their power. I smile when I say that because is it really? Because what they're saying is, it's not my view. It's not my view of what this Constitution ought to mean. This is not personal. And if you do it in any other way than originalism, they say, it's personal. All you're doing is reflecting your values and your priorities and your views in the way you determine meaning in the Constitution, and you're going to just interpret things in your direction.
Isn't that kind of crazy though, since the Constitution is a living document? How can
Well,
you be a
you know.
type one originalist and say that?
Yeah, but again, I mean, they don't believe it's a living document in the same sense you do, though.
They say they
That's it.
don't, but.
But you know, the question is, do they do what they say? But
They don't.
this is supposed to be a constraint, which means they're saying, we the originalists, we are constrained by the original meaning. We can't go outside of that. We have to assign that, and we have to apply that. Well, you can debate how well this translates into practice, but this is what they say. Now, I want you to note before we go on here, there is an open question about whether the Civil War amendments to the United States Constitution, and I'm talking about the amendments that go 13, 14, 15, 16, those amendments, whether the meaning is fixed there at the time those amendments were adopted, which would have been 1870, roughly 1869, I think was the actual date, or whether somehow their meaning goes back to 1789. Well, how could that be? You know, because those amendments certainly were not around in 1689. Well, it's because some of the provisions, like equal protection and due process in the 14th Amendment, have been interpreted by the US Supreme Court as incorporating rights that are in the first 10 amendments to the Constitution, the Bill of Rights, which goes back to this very early period. And remember too, the original Constitution that got ratified did not have any amendments attached to it. That happened very quickly thereafter. In 1789, another set went out, and this was the Bill of Rights, the first 10. But it didn't have them, and that was a matter of debate. There was a group called the Anti-Federalists who said, wait a minute, what about our rights? What protects the rights that we have? There's no Bill of Rights in this Constitution. And that was a source of opposition. They overcame that by all kinds of promises, which they then kept, unlike a lot of political promises, and that they would provide one immediately. Once the Constitution but it was too late to get it into the middle of the process and redo all of the steps that they'd taken. And so the Constitution was indeed adopted, and they immediately then moved, with the first 10 amendments. There actually were more than 10, but there were a couple that were not ratified. One of them came back to haunt us. It is the most recent amendment, which is the proposal that Congress cannot give itself a raise in salary unless there is an election separating the proposal for the raise and the effectiveness of the raise. That was in the first amendments and was defeated, and then came back, and we now have it. It's in the Constitution, but that has to happen. So you at least have to have an off-year election, House of Representatives election, before those salaries can go up. So the people can literally say, "Wait a minute, you guys are gouging us too much, and you're either going to keep your same salary, or we're gonna knock you out of here." Hasn't happened, by the way, but that's the way things are now. Let's see. Oh my goodness, no, this isn't working again. Okay, let me advance my slide here.
It might work on a computer, but just made it work.
Oh, I see. There was something up on my screen on my computer. Yeah, okay.
Okay.
All right. Okay, now, Antonin Scalia, famous justice, yes.
They can't raise their salaries, but what about lobbyists?
There isn't anything about lobbying. The Constitution, perhaps unfortunately, not dealt with. The Citizens United problem, of course, is not dealt with. Citizens United really puzzled me. It still puzzles me to this day. How can I'm speaking. Right. I don't get it. I don't get it. But in any event, that's what the US Supreme Court has said.
That's almost not funny.
That's almost not funny. It is not funny at all, really.
Right.
Scalia, Justice of the United States Supreme Court, one of the key justices in turning the court in a right-wing direction. Scalia explained the difference between his philosophy and the philosophy of Clarence Thomas. Now, both of these guys are originalists, but Scalia said, look,
You think he's a meaning too guy?
I'm an originalist, but I'm not a nut. He's a nut. The reason I picked out Thomas, and I'm picking on Thomas today. It would be easy to pick on Thomas, but Thomas, all of a sudden, guys, in the last 2 terms of the court, I don't have the exact statistics for you, but I am seeing him write more majority opinions, which are the law. When you look at a big stack of opinions from the US Supreme Court, it's the majority opinion plus anything else you can sort out that everybody agrees on, or at least 5 agree on to add to that. Yeah, Brad.
There's a wonderful PBS Frontline 2-hour episode on Jenny and Clarence Thomas that goes through their history from birth to date, which gives you a really interesting perspective on where they're coming from that I highly recommend.
Yeah, was that recent, Brad?
Yes, it's within the last 3 months.
Yeah, I thought so. Yeah, and Thomas rose through the Republican ranks in an interesting kind of way. he met Ronald Reagan because Reagan was speaking in a rally someplace in the Midwest. And Thomas was in the audience. And Reagan was giving a speech and he looks out over the audience. And he sees, of course, what?
That's my African-American supporter, right?
Yes, he sees a sea of white faces with one exception. Thomas is sitting out there. So it was almost no different, except for Thomas, than it would have been at the founding, of the Republic, with white faces all over the place. But Reagan saw that and he went to a member of his staff and he said, we gotta watch this guy. We gotta let's see what he's one of us, but
How can we use
we're
that?
gonna have to deal with that. We're gonna have to deal with that. Well, and then he had a series of jobs that he was given. He was head of the Equal Employment Opportunities Commission. Boy, and then eventually they got him on the bench. I think he served on the DC Circuit for a short time before they got him this Supreme Court appointment. And George H.W. Bush did that appointment. It wasn't Reagan, but by that time it was George H.W. Bush who picked him out. And I think really I pictured George H.W. Bush at just laughing hysterically when he made that appointment. Laughing at the Senate and saying to himself, I've got you guys pinned. I've really got you guys pinned because, first of all, where are you going to go to attack an appointee like this guy? He went to Holy Cross as an undergraduate. And where did he go to law school? Yale Law School, which is one of the, or maybe the number one, and sometimes people debate about whether it's Harvard or Yale or whatever. But this guy's education, his qualifications to be a justice could not be questioned by those clowns in the Senate, excuse my expression, because that is coin of the realm on the East Coast.
And he's one of our guys.
And he's one of our guys. How many of the current court graduated from the Harvard Law School? Yeah, right.
Yeah, the part of the plot line that I found most interesting is the pre-Reagan stuff. So, he studied to be a pastor, dropped out, went to Holy Cross, was sympathetic to the Black Panther movement. That whole part of
Not a pastor, a priest.
Yeah, priest, yeah.
Priest, yeah.
So that whole part of his journey is really interesting and how he came from that to what he is today. Is really
Well, and yeah. I mean, he certainly reflects parts of that journey and what he is today. But a fascinating character, but a character that is really extreme in his originalism, extreme in many of the things that he espouses and believes. And of course, extreme, okay, you got a 9-member court. Extreme means he writes dissents, maybe he writes a lot of concurring opinions. If he agrees with the majority where he explains how this fits with his particular philosophy, but that stuff doesn't count. It's not the law. A dissenting opinion is not the law. A concurring opinion that is not shared by 4 other justices is not the law.
Has he ever written anything himself? I don't think he has, has he?
Well, you mean, what do you mean? You mean,
Has he ever written an opinion?
oh yeah, he's written lots of opinions from the point that he started. But most of them were concurrences or dissents at that time. And of course, they didn't reflect the law. So nobody worries much about a guy like this. He can be, as Scalia described him, he can be a nut. But, the nut isn't going to give us any problems. But wait, watch what happens. Because Now, you're seeing Clarence Thomas for the court. And so everything in there, including some things we're gonna study here. Now, here's Clarence Thomas for the court in New York Pistol Association versus Bruin, 2020 decision. And I'm gonna read this
Look at
through
that
with you,
language. Yeah,
because this is
sorry.
very interesting. Throughout modern Anglo-American history, the right to keep and bear arms in public has traditionally been subject to well-defined restrictions governing the intent for which one could carry arms, the manner of carry, or the exceptional circumstances in which one could not carry arms. But apart from a handful of late 19th century jurisdictions, the historical record compiled by respondents, that's in this case, this is the New York government, does not demonstrate a tradition of broadly prohibiting the public carry of commonly used firearms for self-defense, nor is there any such historical tradition limiting public carry only to those law-abiding citizens who demonstrate a special need for self-defense. We conclude that respondents have failed to meet their burden to identify an American tradition justifying New York's proper cause requirements under Heller's, that's the decision that created the Second Amendment right, text and history standard. The proper cause requirement is therefore unconstitutional. Striking down a New York statute that said, in order to have a gun open carry, you have to apply for a permit. You have to have a good reason why you need it for self-defense. Well, that's out. That's unconstitutional, says Thomas for the court. This is the court saying this, the whole court saying this. This is a very originalist approach to this. He's looking for an original tradition for evidence of what happened at the time, and finding only a smattering of restrictions. He says, well, that other restrictions are in the garbage can. Now, okay, contrast that with what we have had to this point. We have a number of justices that still espouse this, something we'll call pluralism, where you don't just look at the original intent, but you don't not look at that either. You don't, it's not forbidden. You read that, but you look at the text. What does it say? What's the plain meaning of the words? The structure, the precedent, the ethos of the American social order that goes with the provision, and prudence.
Common sense.
Common sense. Common sense. You use common sense to arrive at a constitutional interpretation. The text and the history are not constraints. They operate at the same level as other factors. So it's one of a number of things we're going to look at. We're going to look broadly at all kinds of different things. But then when we add it all up, we're going to look at everything before we come to a meaning. And that meaning is going to reflect common sense and the circumstances of today.
Yeah.
Okay.
Tony,
Yes.
one of the things then, and I believe I read it, and I somewhere in the 60s, I believe, that the state of California even said that laws are to be written for the common man to understand.
Yes.
That's what I'm seeing there. However, they don't do it that way. When you're sitting there saying the initiatives and all this stuff, a lot of that stuff initiative, you gotta sit there and refer to some of the language that they use in the dictionaries, whatever. My problem with the initiatives was that there was always a rider attached to the good ones. 1984, good example. I don't even remember what the law was that they were trying to pass, but there was a rider attached to that said there was be a 5 cents increase in your gasoline cans. Next morning, I come in and everybody's at the office. I said, man, I gotta pay. I said, I told you not to vote for that. Those riders. How They get passed, but people don't know about those.
Well,
I've run across a couple of those riders that really burn my butt.
again, we.
Buyer beware.
We have to
Yeah.
talk about, yes, buyer beware and, you know, you look at the publicity to see who opposes it, who favors it, and what they are saying about what it's going to do and why that's good or bad. You know, obviously, we have a lot of things that are flying at us on the ballot all the time. And sometimes, you know, something, you look at it and, well, are we gonna raise the wages? You know, minimum wage. Are we gonna adjust that? And they immediately get us all thinking, oh, you know, we're gonna raise up all of these people, you know, and that's gonna be great. Well, but all of a sudden we have a different voice coming out of that debate. And that is the people that run some of those fast food restaurants, for example, that tend to be franchises. And what is this gonna do to them? You know, how is this gonna have an impact on them? Are they gonna be able to make it? Because their margins are very thin. So those are the kinds of things we're supposed to sort out in publicity and in debate. Sometimes it works and sometimes it doesn't. But now, all right, now we'll get to what I promised you we would do last time, and we're already a way down the road. The Second Amendment. We had a Second Amendment right created in the case of Heller, which came before Bruin. Bruin is the case that we've just been talking about, where Thomas wrote the opinion, and I just quoted from it. The Second Amendment, here's the language. Now we'll start with text. Text is a factor. So we'll look at the language. And here's what a number of you were talking about last time. A well-regulated militia. Notice the folks that wrote the Constitution had a kind of a weird sense of capitalization. If they thought some word was important, they would capitalize it, even though normal grammar wouldn't dictate that.
Right.
And this is an example. A well-regulated militia, initial caps, being necessary to the security of a free state. Comma, the right of the people to keep and bear arms shall not be infringed. Okay, let's just look at the text, not look at anything else. Let's just look at those words. How would we take that apart? How would we break that down, and what meaning would we assign to that?
Look at the ground.
Let me take a stab at it.
Yeah, Lawson.
A well-regulated militia. If I write this and I capitalize militia, I'm implying that this is an organization that we're talking about and not individuals. And if I write a well-regulated militia, again, I'm implying this is an organization for a singular purpose. Obviously, what they were really saying here is that we don't want another King James over here. If this new government that we're forming with this Constitution is going to work for us, we don't want them to get dirty. We don't want them to become bad guys. But if they do become bad guys, we want it written by law that we can have guns and do this revolutionary warfare all over again. Necessary to the security of a free state.
Of a free
That's right.
state. Initial
That's right.
caps on state.
But there was no, go ahead.
I'm looking at, the
Yeah.
terminology of well-regulated militia. I believe at that point, to me, that would be the armed forces.
Right.
Something to defend our country and defend us against other.
Like a
things there.
National Guard, yeah.
The National Guard, the US Army, whatever else.
Well, except that.
That's what I see the first part.
What form would that take? Because, you know,
I know there's a Michigan militia and they were all illegal people.
well,
Well, the Proud Boys are also kind of militia, right? Or,
yeah.
and they're in jail now for what, many of them.
Yes, ma'am.
Well, the Swiss cantons is what I've always thought.
Right.
Yeah.
This would be like.
Yeah, well, and those models were debated among the founders. Has anybody ever looked at visited either Thomas Jefferson's home at Monticello or James Madison's home? James Madison had 4,000 books in his library, which was a magnificent library at that time. You look at what was there, it was about the Swiss cantons, it was about how Venice was run, it was about Rome and Greece and all this kind of stuff. They used all of that stuff in their reading to inform them, yeah.
I used to live in Switzerland,
Yeah,
way back in the 50s and 60s. And when I lived there in Switzerland, every able-bodied young man had been in the military and was on reserve duty. Now, this is a country that throughout the Second World War was a neutral country. And every able-bodied man was a reserve soldier, had his military rifle in his home, and had a box of munition enough to get him able to fight his way to the nearest place where there was an organized army unit. So every able-bodied man could fight his way to a place where there was, you know, a military unit. And that was the defense for a nation that was the peacekeeper of the world at the time. And that's the kind of thing I do believe the founders had in mind.
I agree. And I didn't quite finish. Being necessary for the security of a free state. Why would I capitalize state? The same reason I capitalized militia, an organized method to fight against our own government that became bad. Just like the one we left to come here as colonists. The right of the people to keep them their own shall not be infringed. And this is what it's saying is that the government, our United States government, should never have the right to tell us that we cannot fight against it, either with words or with bullets and muskets. I think that's what that really means.
anybody have an alternative reading?
Tony, I was wondering,
Yeah,
can I interject?
Let's do.
This country, there's a real misunderstanding of you know, citizenship in this country. We are United States citizens first, and then state citizens.
Agreed.
And this country has never been invaded by a foreign power. So we really do not understand what it's like to have to defend the country. If you read that wonderful book, 1776, you understand in reading the book 1776, why the founders of the Constitution wanted everybody to have, you know, if preferably a rifle in their home, because that's what gave us the ability to fight the British. And you know, that's, and we no longer understand what it's like to be invaded by a foreign country. We don't get it.
When were we invaded by a foreign power?
Not since the British.
Well.
That's
Pearl Harbor.
No, invaded.
Pearl Harbor, well, you know, Pearl Harbor, I don't know, that's an attack.
The Aleutian Islands in World War II.
So we were invaded once. That was an invasion after, I mean, that's after the Revolutionary War. Of course, we were invaded in the Revolutionary War too. It was an invasion, came from multiple directions. But yeah, okay, those concepts are there. Does anybody disagree? Does anybody have any other points to make about what this thing means? Anybody disagree with those meetings?
It certainly doesn't mean that everybody has a right to walk the streets when they are 15. They were talking muskets and whatnot.
I don't see AR or AK in here.
There are articles that kind of specifies what's a militia before it was written.
Well, there is an understanding of what militia is, but it's not a defined term. There's nothing here that defines that term.
It doesn't even says firearms thing. It says arms.
Well, the word,
So,
yeah.
I mean, it doesn't even says firearms, right? So that's also open for interpretation, because back then it could be a sword or a whatever, pick it, whatever that you could pick up to go against the government.
Well, and again,
It does not say AKs, AR. That's true.
there are arms of the time, and that included these sort of clunky looking rifles that, the funny commercials always demonstrate how, most people couldn't hit the broadside of a barn with those guns. But they also included pistols.
And cannons.
They had pistols, they had cannon, they had field cannon, and they had swords. And they had shorter daggers, dirks, those kinds of things. Yeah.
This is just, I guess, personal feelings, but I feel like a lot of people are bearing arms that I would be really afraid of. A lot of, I hate to say it, but my Republican friends are bearing arms now. And like in my own family, my cousin has 14 guns in his house to guard against anyone, especially government or whatever, that might come and, be of
Right.
threat. Yeah. And I feel like a lot of people that are bearing arms are kind of against people that are peacemakers.
Well, I mean, yeah.
On that one there, I sit there and I say, when I was in the service, I was trained on M14, M16, laws, rockets, howitzers, and all the other kind of stuff like that. Right now, the military's carrying AKs, ARs, and whatever else. When they've got all kinds of sophisticated, it's all laser now. The problem is that we, the people, aren't able to fight those things. So how can we, if the military rises up against the people, how do you defend them? How do they defend themselves? Your brother, your uncle, whoever has the 14 weapons, hopefully he has 10,000 rounds too, because he's going to need them.
That's an interesting question.
This is interesting, folks. Let me point out a couple of things about this language. The object of this, and the object is important to understand any law, is what's the purpose? What's the object? What are we trying to accomplish here? First of all, it's a well-regulated militia. This is not a ragtag bunch of, I'm a Proud Boy thing here. This is a well-regulated, disciplined group of arms bearers who are trained to do what they're doing. The well-regulated aspect of that did have an understanding then as now, as to what that means. But the objective here is necessary to the security of a free state. Well, the state's security would need to be threatened here. It's not simply the state doesn't like what the federal government does, and therefore announces that because somebody won the election and somebody lost the election, that their security has been threatened. No, your security hasn't been threatened. This is to have a well-regulated militia to preserve the security of your state. This was at a time when the national armed forces were extremely weak and ephemeral. We hadn't built up the kinds of armed forces we have now because we just got people. We went out to the states and said, please send us some people so we can have an army under George Washington to fight this revolution, to mount the revolution. The security of a free state this is a very narrow language base here for this. And then we haven't gotten to the last part of it. Yeah.
It's worth remembering an instance that occurred when the soldiers returned from the revolution that hadn't been paid yet. And there's this instance, I believe in Philadelphia, where there was a kind of rabble-rousing group of the returning soldiers that were trying to affect the outcome of the vote, of a legislative vote by the then Congress. And George Washington, who was out of state, got together the militia and came and dispersed the rabble-rousers, because he was there to secure the security of the Congress. And that's what we're talking about. You understand that this is to that point. If there's a home based lack of security, it's the military that secures us. It's not some local group of whatever's political individual.
So Tony, the text purely says it's a narrow kind of a thing. And
Very narrow,
it's
very
based,
narrow.
it's based at the time when the revolution had ended, the armies had been dispersed, you know, and so people were going back to their homes, and they had their guns to begin with. They probably brought their guns, and they were going back to their homes. And so this was in there to, you know, to talk about what we might do in the case of our state being attacked.
Or
How do we get from that, what we read in the text as very narrow, to where we are today, where it looks like that has been totally thrown out, and the only thing that is focused on by the courts is keep and bear arms?
Thank you, Jim. That's the next slide. All right, explanation of this clause. This is Scalia writing now. This is not the nut. This is the guy who considers himself an originalist.
This is the old.
It is therefore entirely sensible, he says, that the Second Amendment prefatory clause, and this is the whole business about a well-regulated militia being necessary to the security of a free state. That prefatory clause announces the purpose for which the right was codified: to prevent elimination of the militia. So you had militias at this time. There were militias around. Some of them had been devoted to the cause of fighting the revolution. But now we're at the time when these militias could be discharged and could be taken away. And so Scalia says the elimination of the militias. Now, by the way, he didn't have anything to support this, but that's what he says. The prefatory clause does not suggest that preserving the militia was the only reason Americans valued the ancient right to keep and bear arms. How did this get to be an ancient right? Most undoubtedly thought it even more important for self-defense and hunting. This all his assumptions now, but the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that right, unlike some other English rights, was codified in a written constitution. Well, okay, where does he get all of this? But this was his reasoning for saying that this is just fine, and it's got to extend to not just having this thing in your home, but being able to carry these arms with you wherever you go, because wherever you go, your right of self-defense might be threatened.
But he drops the capital on militia.
It does. It really drops that whole clause altogether.
That's right.
Because shouldn't the question here And this is, what I'm suggesting here is radical. The Supreme Court has voted against this. But the way I read this language is, look, this is a narrow provision designed to protect a well-regulated militia. And therefore shouldn't, like most government enactments, it be assumed that this, the purpose of this whole thing is valid, and therefore anyone who attacks it has got to carry the burden of proving that whatever they're proposing is essential to having a well-regulated militia that can protect the security of a free state. Don't they have to prove that? We've got it backwards. We've got it all the way around the other way. All of a sudden, it's the government that walks into court having regulated arms in some way, and it has the burden of proving that there won't be any infringement of the rights, which are going to be broadly construed, of self-defense, and that therefore, and these, what we got, folks, is this is continuing to expand. It is continuing to expand. We are now getting cases coming up through the lower courts that are dealing with people who have been convicted of crimes. And the argument is, well, I mean, you know, all I did was engage in shoplifting or you know, some crime like that, and now you've taken away my gun. And that doesn't, you know, and believe it or not, one of the circuits dealt with just that situation in a case that came out a few months ago, and that's on its way to the U.S. Supreme Court. There was an en banc decision, which means every judge in the circuit, probably about 15 judges, sat on that case, and they voted. They struck that down. They said, no, the state can't say that a shoplifter, you know, can't have his gun.
So we don't want to let these people vote, but it's okay if they can have a gun.
For one minute, he's a shoplifter, next thing he said he was being an armed robber. I don't know, but can't the state put that limit on? No, because the state is looked at in a hostile way in relation to this right. And Thomas, in the opinion that we've been quoting from in the text that I didn't give you, because it would put you to sleep, he goes on and on and on, and he says, this right, this sacred right, is ancient and sacred right, is just like freedom of speech, and it's just like freedom of religion. Wow. Holy Moses. I mean, stop a minute. I mean, one of these so-called rights is based on action that poses a danger to other human beings. Speech doesn't do that. Religion doesn't do that. These are matters of expression through groups and through individuals expressing things. And we have a whole body of law, yes, that interprets those things very broadly and is very hostile to government regulation of our speech and of our religion. But I mean, no problem with that. But for him to say this is the equivalent of that is just an amazing leap of something. So, okay.
Scary.
When the Second Amendment's plain text, which contains, says Thomas, an unqualified command, the right to keep and bear arms is an unqualified command. It covers the plaintiff's conduct. It is presumptively protected. In other words, we're going to assume it's protected, and the burden's going to be on the government to show the contrary.
Now, when it's a comma after what precedes it.
Well, you know, they're ignoring the purpose of this protection.
Totally.
And the purpose of the protection is vital to assuming or dealing with how broad it's going to be. Government must justify the regulation by demonstrating consistency with historical tradition of firearm regulation. So you have to look at the history of this and say, oh, well, yeah, in you know, in 1782,
With muskets.
here we had a state that did this. It said you can't have your guns in church. You know, and there have been a number of those laws, by the way, that restrict the place, not in church, not in schools, and there are some other places that are listed as places where you shouldn't have guns.
Bar.
Well, I mean, okay, but then that's, you have to show that kind of tradition with respect to whatever you're, so, but of course, we didn't have ARs and we didn't have AKs. So how the heck am I gonna show you a tradition with those kinds of weapons? I just am not gonna be able to do that. I lose, you know, at the get-go. So they're putting an impossible burden on someone to uphold one of these laws. Treat a Second Amendment claim like free speech and free exercise. Burden is on the party opposing the claim. Keep and bear naturally encompasses public carrying to enable a readiness for self-defense. I've got to be ready to defend myself. So, you know, but I mean, for goodness sake, look at the folks, look at the attacks on churches. How could I say if I had a regulation that you shouldn't have or can't have a gun in church, in a church or a place of worship, how could I not say I won't need it for self-defense? You know, that place. Oh my goodness, look at the Pittsburgh synagogue case, was just tried this week. And there's a case where it would have been handy, you know, that kind of thing. But that's not the point. Like the First Amendment, like you must have a some kind of historical meaning, historical circumstance. All instruments that constitute bearable arms, even those that were not in existence at the time of the founding. That language chills me, just chills me. All instruments that constitute bearable arms. Bearable, what's a bearable arm? It means I can pick it up and carry it. Oh, I can carry an AR. I can carry an AK. I can carry a lot of things.
A bazooka.
And they're getting, their weapons are getting better and better in terms of their carryability, portability. So, you know, continuing controversies. Okay, now.
What about backpack?
Okay, we're gonna move. What about a backpack? Well, you know, is for tort law purposes, a backpack would be regarded as part of your person. And so I would think you could make a good argument there if it's stuck in your backpack. And of course, you can have all kinds of things there. But what about explosives of various kinds? What about C4? How much? No, C4 are very portable. Very portable. Hand grenades, and hand grenades are getting more lethal all the time. They're packing more power into what goes on in there. Amazing stuff, amazing stuff. And this is, but all of these spaces where the camel can stick its nose and then go charging into the tent, they're all over this law now. They're not in the Second Amendment, as I hope you can see. They don't come from the language of the amendment. They come from a preconceived idea about what this ought to be that got picked up somehow.
Secret. I mean, it is religion.
Yeah.
So what's the justification then for you not being allowed to take a gun into the Supreme Court?
Well, you know, I would say this
justifies regulation by demonstrating consistency with its historical tradition.
This is an eloquent demonstration of that, because if they allowed me to take a gun in there, I might well shoot somebody, you know, and it's probably gonna be somebody on the bench. I mean, maybe the nut, you know, I don't know. But okay, I mean, this is the kind of thing. So, okay, all right, now we're gonna switch topic. Any questions or anything? I'm gonna let it, yeah, I'm gonna let it sit there. We'll go to
Sorry, I do have
the
a
fourth
question.
branch next time.
So if this is now part of the law, this crazy interpretation, right? Because it's been written by the Supreme Court, correct? I mean, the Second Amendment doesn't have it, but now all these things have been added in terms of interpretation.
By court decision,
Right.
yes.
So what law supersedes this? For example, for a person not to carry a gun into a plane, which you can't do. I mean, you can carry a gun, but not ammunition. So nobody walks today into a plane.
Right.
But you can feel threatened in a plane. So my point is like,
Oh,
under
yeah.
the same logic, I may want to defend myself. So what?
The
How do they
plane could
come
be-
along with this to say, no, you can't?
They claim I mean, you could have, the plane could be hijacked. So you could have that, but no, the distinction is this. For the plane, for the court, for the church,
Right.
they're discrete places that the historical tradition identifies. So you can look back and you can see a pattern of legislation controlling use or banning use in those places. And so it's a place directed regulation, and it's upheld for that reason. And all you have to do to establish that, if you're the government defending it, is you say, well, okay, this is when we put planes in the air, and here's when somebody tried to carry a gun, and we made a rule, and blah, 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 blah. We've had that for, I don't know, 50 years, 75 years, 100 years.
That's whatever. Nobody, regardless of their political persuasion, is going to disagree with that.
Yeah.
Those things are easy.
Yeah, yeah. Well, and they are easier in any event. Any other questions about this topic? We've obviously gotten into the gun control thing, but I wanted to talk about it as an illustration of how we take apart the language of this stuff. We have to look at the language, but then we also have to look at the history. According to some judges, that's constraining and controlling. According to other judges, we have to look at the circumstances, including the modern circumstances. So this is the way we interpret and the way we argue about these things. And we're going to continue to have it in the Second Amendment. Second Amendment is just full of problems. And given the approach that they've taken, they guaranteed that these cases are going to be inundating them. Every crime that's conceivable to deny somebody the right to carry arms, every mental condition that's conceivable. They believe me, the NRA and the NRA's lawyers are sitting here right now. On Sunday, maybe not all of them, but they're sitting here and they're asking the question: okay, what's the best case we can take to the U.S. Supreme Court for knocking out legislation that deals with banning the right to bear arms if you were convicted of a crime? What's the best one we can get? Oh, well, here's one that's shoplifting, for goodness sake. You know, Clarence Thomas and the rest of them will take a look at that and say, well, my gosh, that's just, so let's try to get that one up there. And that's what they do. That's what they do. They pick out the cases from the lower courts that they want to get up there, and they aim them. And they aim them even when they start the case in the first place, when they sue and challenge a particular regulation. But they're going to attack every aspect of this. And you notice that we haven't seen an AR or an AK case. Why is that? It's because those lawyers have decided it would be stupid to go into a fight and lead with your chin, and that's like a hit me example. So we don't want that to be first. We want to build up to that, and then eventually we'll find an AR or an AK case from some neighborhood that is, our former president used to use terms that started with SH to refer to neighborhoods he didn't like, countries he didn't like, places he didn't like. Well, you take one of those places, and this is a really rough neighborhood, and I need my AR-15 for self-defense here in this neighborhood,
And lobbyists, because I know the NRA is a very active lobbyist, can they influence the Supreme Court at all, or just the senators and representatives?
Not directly. They can't go behind the scenes. The court, if you wrote a letter to the court as a lobbyist, or you went and showed up and say, I want to meet with a justice, you would never get anywhere near that person, and your letter or note or whatever would go into a big pile that they collect of what they receive, and it would never get to any member of the court that would make a decision. So they're protected from any direct influence.
But you could tell them I take you on holidays and pay $5 for you to come on my yacht. I mean, you can do that.
This is what I'm talking about and would describe as indirect influence. Although it's pretty damn direct if you're the one that's on the yacht. But I mean, yeah, there are ways you can do it. And I've noticed that, you know, that whole thing has died down now in the press. We haven't heard about it for weeks. I'm a little disturbed by that. I don't see any reason, folks, why federal judges and particularly US Supreme Court justices shouldn't be governed by the same standards any other government official would be governed by. Because why? What's the matter with that? We used to have cases in California where we get a case in the Supreme Court where it would be challenged, you know, that the legislature is messing with the powers of the Supreme Court to regulate lawyers, for example, which is a traditional power the Supreme Court has in California. And the court would say, wait a minute, if the regulation makes sense, we're gonna leave it alone, you know, yeah, I mean, we could have done the same thing, but you know, so what? We're gonna leave that alone. And that's you know, the way that ought to happen. Judges ought to regulate themselves on this if they're not already regulated. But you know, I don't know, watch, see what happens. Okay, I guess we're done. So thanks, everybody.
Thanks.